วิดีโอนี้แม่นสารจำลองระหว่างฝ่ายองค์การอัยการและฝ่ายแดนจันทร์พุทธไสยในกรณีการค้าสิ่งเสพติดและการฟอกเงินนำแสดงโดย
The Honorable Judge Al-Jawridi is now presiding the session to hear the case against Mr. Danchan Phoudthaxay.
Thank you. The court hearing is now open. Mr. Phoudthaxay, we are here today because you have been arrested at the Lao Thai Friendship Bridge in Vientiane district on the 4th of July 2019 at 11:35. And you are here to determine your responsibility regarding the charges that you face according to the order of the prosecution issued on the 10th of January 2020. The first charge is drug trafficking against Article 315 of the Penal Code is that on the 4th of July you transported 500 capsules of ice which were tested positive for crystal meth. Additionally, you are charged with the crime of money laundering against Article 130 of the Penal Code in that not only were you arrested with $500,000 in cash at the border, but evidence indicated the course of conduct that you took steps to disguise the proceeds of your illegal activities. Mr. Phoudthaxay, there are several people in this room who I would like to explain their role to you. Firstly, my name is Al-Jawridi, I'm the judge. My role is to decide whether you are guilty or not guilty after hearing all the evidence. Here we have Mr. Lawrence Siri from the prosecutor's office who would have to prove the charge against you. And standing next to you is your attorney, Mr. Max Muller, who will have the opportunity to defend you. Mr. Phoudthaxay, have you been informed of these charges as provided by Article 185 of the Law on Criminal Procedure?
Yes.
Please state your name, date, and place of birth and function.
My name is Danchan Phoudthaxay. I was born on February 14, 1988 in Vientiane capital, Lao PDR. I'm married with 2 children.
What is your profession, please?
I'm a car wash manager.
Is your business successful?
No, my business doesn't run really well.
Do you earn enough money to take care of your family?
No.
Well, we will examine the 2 charges in turn, starting with evidence. The customs officers found 500 ice capsules in your luggage. Do you have anything to declare about this?
I keep my statement made in the police report, and I want to let my lawyer to speak.
Yes.
Mr. Siri, could you please show the court the items seized and explain how they were found?
We have a copy of the defendant's passport which was seized from him at the Thai Lao Friendship Bridge. I will present this to the clerk. That establishes his identity as the person who was arrested on that day. Secondly, Your Honor, we have what's been marked as exhibit number 2, and that is the drugs that were seized from the defendant at the Thai Bridge. His signature or thumbprint is placed on the bag as proof that it was shown to him at the time of his arrest.
Does the prosecution have any evidence that this is drug?
Yes, Your Honor, we do. We have a lab report marked as exhibit number 3, which is from the Lao Forensic Lab here in Vientiane. This is 500 capsules which actually tested positive for methamphetamines in the amount of 2.9 kilograms. We would present this as exhibit number 3.
Thank you, Mr. Siri. Does the defense wish to speak?
Yes, Your Honor. For a long time there have been rumors saying that the lab does not have proper equipment to test drugs. The drug test is essential for the outcome of the case. I believe that there is an irregularity regarding this evidence, and therefore the forensic report is not reliable. Hence, the prosecution is not capable of proving that the seized products are illegal drugs.
Does the prosecution wish to reply?
Absolutely, Your Honor. The lab is attached to the Food and Drug Quality Control Center of the Ministry of Health and provides support services for law enforcement, for the police, for customs, and the judiciary, as well as vital health services such as drug abuse prevention and treatment and rehabilitation programs, and toxicology services. These are nothing more than rumors, Your Honor. It's reliable.
Does the defense wish to add something?
No, Your Honor. I will develop my other arguments relating this matter in my plea.
The defendant is also charged for money laundering. Could the prosecution present the pieces of evidence that led to these charges?
Yes, Your Excellency. We have several pieces regarding the money laundering charge. The following items were seized from the defendant on the 4th of July at the Friendship Bridge. The seizure of these items was recorded pursuant to Articles 100 and 126 of the Lao Criminal Procedure Code, and in that the defendant was read what the articles were and gave his fingerprint as evidence that he understood this. Firstly, I will present to the court a picture of the $500,000 that were seized in cash, by the way, that were seized from the suitcase carried by the suspect along with the drugs which served as the basis of the drug charge and which is the predicate offense for the money laundering charge. The next piece of evidence I have for the court are a number of calling cards or business cards that were seized from the defendant in his wallet, and they are for accountants and money exchanges in Vientiane and Phnom Penh and Bangkok. This is exhibit number 5, Your Honor. Next, we have a receipt for $2,200 for 3 emerald rings, which were bought in Vientiane on May 28th, 2019. This was found in the wallet of the defendant at the time of his arrest, as well as a receipt for $4,700 for 3 diamond rings that were bought in Hanoi on June 10th, 2019. Also found in the handbag carried by the defendant. This is exhibit number 7. Next, I have a deposit slip in the amount of $2,000 from the Big Blue Bank in Vientiane dated June 28th, 2019, which was found in the wallet of the defendant. This is exhibit number 5. Next, Your Honor, we have a vehicle purchase agreement for a Porsche Cheyenne valued at $94,000, which was signed in Vientiane on the 11th of June 2019. This purchase agreement is in the name of Mr. Phoudthaxay, the defendant. Number 9, Your Honor, we have a safety deposit receipt in the amount of $3,000 from the BCEL Bank here in Vientiane. There's also a receipt for $2,500 from the Big Blue Bank in Vientiane, found in the handbag of the defendant at the time of his arrest. As exhibit number 10, Your Honor, we have a certificate of incorporation in the name of the car wash Phoudthaxay Company, which was seized from the defendant in his belongings at the time of his arrest on the 4th of July at the Friendship Bridge. And lastly, Your Honor, is exhibit number 11, It is the deposit slip which shows a deposit of $5,000 an account in the name of the defendant into the Big Blue Bank of Vientiane, with the balance of the account of $80,000. Your Honor, I would just like to point out that the further investigation through the mutual legal assistance request determined that the defendant has no legitimate source of income and he was not employed at the time of his arrest or the preceding 5 years. This relates to the last piece of evidence that I presented. And under questioning just 20 minutes ago, the defendant confirmed that he is not employed and is not able to support himself.
Thank you, Mr. Siri. Mr. Phoudthaxay, do those items belong to you?
I use my rights to remain silent.
Mr. Siri, could you please explain to the Chamber how is the prosecution establishing the connection between these belongings and the proceeds of crime?
Yes, Your Honor. First of all, I would, regarding the drug charge, was caught with the contraband at the checkpoint as he attempted to traffic the crystal meth into Lao PDR. It was his bag and his possession. It was collected according to the protocol and was tested by the lab here in Laos, the official lab. There are no irregularities in the collection of this evidence, and there's nothing other than guilt that can be drawn from the circumstances of the evidence. He possessed 2.9 kilograms of crystal meth, and he brought it into this country. He is guilty of violating Article 315 of the Criminal Code. Regarding the second charge of money laundering, the evidence, Your Honor, is clear. First, the prosecution points the court's attention to the predicate offense of the drug offense that I just talked about, drug trafficking. Mr. Phoudthaxay was attempting to turn the illegal proceeds from this crime, from these drug trade, into assets that could be easily be seen as clean money. He was trying to disguise the money's illegality. He bought things such as emerald rings and diamond rings, items that were expensive and valuable and that could be sold to convert the profits into legitimate assets. The Porsche automobile is a good example of this. The contract was for $94,000, yet the defendant has no source of income, no source other than the cash that he earned from selling drugs. Some of that cash he was arrested with, $500,000, was seized from a man with no income. The court has also received evidence showing that the car wash company that the defendant was incorporated was not in operation. It was a mere shell to hide the profits of the defendant's illegal drug trade. The court has also received evidence that Mr. Phoudthaxay had deposited large amounts of cash into different bank deposit boxes in Vientiane for a total of $5,500 and deposits for $2,000 into another account at Big Blue Bank here in Vientiane. Lastly, the court took evidence that the defendant had regularly deposited money into a bank in Bangkok in the amount of $80,000 between March and June of last year. All of this from a man who was caught with 2.9 kilograms of crystal meth for a value of $492,000. This and $500,000 in his possession. All of this from a man with no income. Your Excellency, Article 44 of the Law and Criminal Procedure of the Lao People's Democratic Republic provides that, I quote, even the accused person or defendant denies or does not admit such guilt if there is strong and reliable evidence that person may be regarded as the offender. In this case, there is overwhelming evidence that the drugs belong to the defendant and that the defendant sought to disguise the illegal profits in contrary to Article 130 of the Penal Code. And I should add that his trafficking was in contrary to Article 315 of the Penal Code. Thank you, Your Honor.
Thank you, Mr. Siri. Mr. Phoudthaxay, do you want to defend yourself?
No, I want my lawyer to speak.
Counsel Muller, could the defense give its opinion on guilt and criminal liability for the defendant?
Yes, Your Honor. First of all, I need to insist on a severe violation of my client's rights. The law on criminal procedure is very clear, and Article 14 guarantees the right of defense in proceedings. During the first hearing, or the latest at the moment of his arrestation, my client should have been informed and should have been able to consult a lawyer. Failure to do so, my client is now wrongfully accused of crimes he did not commit. That's why I believe the charges must be dismissed. There are several registered exhibits that prove individual and autonomous facts. During a search on the border, the authorities found drugs in a bag. This bag was not locked. Anybody could have opened the bag and put the drugs in it. There is no evidence that could link my client to those drugs. My client is denying that the drugs are his. He did not know there were drugs in it. Since there is no confession, the investigation should have tried to collect further evidence in order to prove that the drugs belong to my client. There are two possibilities. Either the investigation has tried to do so by interviewing other passengers of the bus, or by collecting fingerprints or other DNA samples on the drugs or the plastic bag. I guess that if they did so, they probably did not manage to find fingerprints or other DNA samples or testimonies charging my client. Otherwise, the prosecution would surely have been based on such evidence. Or the investigation just simply failed to do so. Anyway, the consequences are the same. Your Honor, you have to consider these points because there can only be one outcome to this case. My client must be found not guilty. All the other evidence are individual objects or documents that are not illegal. And my client has the right to not explain when, where, how, and why he was in possession of those items on 4th of July. Hence, there cannot be money laundering either, because there's no predicate offense. My client must benefit from the presumption of innocence because the prosecution fails to prove his guilt. My client is married with 2 children. He has no criminal record. All those facts do not match with the profile of the person whose drugs was found. My client did not commit these crimes and must be found not guilty.
Thank you, Counsel. Mr. Siri, does the prosecution wish to respond to the defense submissions?
Yes, Your Honor. If I understand the defense's point or their theory, it would be that the defendant does not deny the suitcase was his, but rather denies that or does not admit that the drugs that were found inside the suitcase or the money were his. This makes no sense. Had the suitcase with the illegal drugs and the $500,000 in cash in his possession, he is guilty of this charge. With reference to the second charge, that of money laundering, the evidence is clear. The defendant had no source of income to explain the money and possessions that he acquired, other than that it was his proceeds from the drug trade. This is further supported by the drugs that were found with him.
Thank you. Counsel Muller, is there any comment or proposal that the defense wished to add?
The prosecution did not understand my theory because we want the cash back. The cash is his. The drugs are not his.
Thank you. Mr. Siri, what are the prosecution's sentencing requests?
Yes, Your Honor. We are submitting a request for a sentence, a life sentence upon the defendant for his guilt in this matter. The life sentence would be for violation of Section 3 or Article 314 of the Penal Code, that of drug trafficking. Additionally, the prosecution seeks a monetary fine in the amount of 1 billion kip. The basis for this recommendation is the amount of drugs seized from the defendant. He was arrested with 2.9 kilograms of methamphetamines. Had the weight been just 0.1 kilogram more, the defendant would be eligible for the imposition of the death penalty. Additionally, evidence deduced from the seizure of the documents from the defendant, for which the money laundering charge is the basis, indicate that the defendant had been involved in drug trafficking for quite some time. This brazen violation of law should not be tolerated nor shown leniency, Your Honor. On the charge of money laundering, the Office of the Prosecutor requests a sentence of 10 years. This would be folded into the life imprisonment sentence for the violation of Article 315 and a fine of 700 million kip, representing the maximum sentence for money laundering in that category. This penalty is now eligible for consolidation under Article 66. The Office of the Prosecutor also asked for a confiscation order for the defendant's assets, as well as an order of destruction for the drugs. Thank you, Your Honor.
Thank you, Mr. Siri. Counsel Muller, does the defense wish to conclude?
Yes, Your Honor, with great pleasure. The prosecution is based on false premises and unproven facts. Bottom line is that my client is a first-time offender and someone put drugs in his bag. It is just not plausible that my client is involved in an alleged criminal organization capable of drug trafficking and more than $500,000 money laundering. My client has to be found not guilty.
Thank you, Counsel. Mr. Phoudthaxay, do you want to say one last thing?
I'm not guilty. I want to say one last thing, that I'm not guilty.
Thank you, Mr. Phoudthaxay. The court hearing is now closed. The chamber will retire to deliberate in closed session. Exceptionally, to serve the purpose of this mock trial, the judgment will be delivered ex tempore.
All rise.
Please sit down. After considering the case, the Chamber comes to the following decision. On behalf of the Lao PDR, Mr. Danchan Phoudthaxay is found guilty for both drug trafficking and money laundering charges in violation of Articles 315 and 130 of the Penal Code regarding the absence of irregularity and the probative value of the evidence presented by the prosecution. As penalties, Mr. Phoudthaxay is sentenced to life imprisonment and a fine in the amount of 1 billion kip for drug trafficking regarding the seriousness of the offense resulting from the quantity of drugs seized and the international aspect of the traffic. For money laundering, Mr. Phoudthaxay is sentenced to 10 years, which is folded into the life imprisonment as provided by Article 66 of the Penal Code, and a fine in the amount of 700,000 kip regarding the significant benefits of the accused criminal activities. All the accused assets will be confiscated, the drug seized will be destroyed when the judgment will be enforceable. Mr. Phoudthaxay, you have the right to appeal the court's decision.
We will appeal. Well, we will appeal, of course.
นำเสนอและสนับสนุนโดย